Now, since we started also, we've been able to connect to 4 identity databases in 4 countries, giving us access to almost 80 million plus identities. And we plan to move into 6 markets so that we can create a Pan-African value that will help onboard 100,000 people who are unbanked by the end of next year. Also, we want to increase access to money by 60%. By 60% by the end of next year as well. So currently, it takes between 2 and 7 working days for a financial service to be able to verify the identity of your client, right? And we're telling them that, no, you can do that in actually 20 seconds. So what we do involves a lot of network because you have to connect identity databases. You have to do a lot of compliance, right? So it involves a lot of legwork and networking. And we are a group of second-time founders who have gained some experience in doing just that. So Paul here is the CEO and the team lead, and he has a very heavy experience in terms of financial inclusion and finance. He's worked with financial organizations. And also what we're doing deals with complex data and also a very complex technology. The data is very sensitive, so you have to have an engineer who knows what he does so that you can lead an engineering team. And Lord is pretty effective at that. So the Universal Declaration of Human Rights, the very first one says that all human beings are born equal, right? And
go ahead. No, wait. Since there was a little technical problem, we're going to give him 1 or 2 more sentences. So finish the thought, please.
It says that all human beings are born equal. And different children born in different places, right? 4 children are born every second. And in different places, they have different levels of access. So for a Rohingya child, for instance, she doesn't have access because no country or nobody recognizes her. So to achieve this, right, we would like to build an all-inclusive world by giving people financial access and financial inclusion. So I would like you to join us on our mission to connect Africans to opportunities all over the world. Thank you.
Okay. Great job. Good pitch. Okay, so I looked to our jury. The mic is with Kanan, but does the jury have a question for Approve?
Yeah, good job. How do you solve the problem of identity itself? So you're talking, what I see here is that your product helps them share the identity and helps institutions verify it. So what of people that don't have ID cards itself? So is your market limited to those that have identity cards?
No. So basically we're using, like we are connected to government databases, but we also, for those guys who don't have identity cards, right, want to use alternative data sources based on, let's say you have a Facebook account, right? You have a Twitter account. You can use that to sort of like over time build a data profile of someone to easily sort of like onboard or verify that person to know whether this person is actually a valid person that you can verify or not. People's location data, people's utility bills, this all count towards things that if you have this access to this data, you can build on top of that to know whether you can verify someone or not.
Good job. My question is, how do you plan to get the word out about Approve in the market? What is your marketing and impact on that?
So currently we generate leads by going directly to the financial service providers and pitching what we do to them, right? Because legally they are mandated to do KYC on their customers, right? So when we go and we pitch the solution to them, it's more of a case where you want to, how should I describe it? You want to improve their processes. It's increase the number of customers they can get, right? So when you pitch to them, they realize the value of this. Then, so we currently use direct communication channels to like onboard our users.
One more question from the jury, or is the jury done on this one? I think they've got their questions answered. So one more round of applause for Approve. Good job. Can I take that? Yep.
Black is beautiful.
This is the remix of that particular song. They came up with that one during the pitch. Okay, so yes, there are some innovations that are focused on money disputes, but many, I would say at least 4 of the startups that we have are not necessarily about money disputes. They focus on other justice problems because there are many. And the next one I'd like to invite is also from here in Nigeria, came all the way down from Jos with their entire team. Please welcome, representing Community Peace Initiative, Christopher Haggleston-Bott.
how do you intend to work in other communities? Is this something that is going to be limited to Plateau State, or do you intend to expand to other parts of Nigeria, and what's your strategy for that?
Well, we intend to expand beyond Plateau, but for now, this was test run in Wasi local government in 2017, like I said, and it actually recorded huge successes. The Department of Citizens' Rights and Law Reforms in the Ministry of Justice has always been doing this, and with this particular innovation, we've also sent proposals to northern parts of the country, that is the rest of the 18 northern parts of the country, so northern states of the country. So we intend to go big. We start small, we start training, and in a short while, I assure you, we'll go bigger.
I noticed your source of funding. Do the disputing parties pay anything like a service fee, or are you just relying on third-party funds?
No. Disputing parties don't have to. These are rural communities. Okay. Now, security, over 90% of security is the sole responsibility of government. Now, if government has reached a hurting stalemate as such from 2001 to 2017, you know that government is actually in need. Whatever solution that would bring peace, government would actually explore. So we capitalize on that. And government, actually, when we started, within 8 months, the local government gave us 6 million naira to proceed. So no individual has to pay.
Okay, one more big round of applause for Community Peace Initiative. Great. Okay, we're going to hear one more Justice Innovation pitch, and then we're going to take a break and hear from our eminent keynote speaker. But here in the last part of this first pitches, please welcome from here in Lagos, representing the Flamer Project, Adejoke Are.
Over a year in prison awaiting trial after his boss, who owned a laundry business, accused him of stealing clothes. There was no proof that Eric committed this offense, but Eric was in prison because neither him nor his aging mother could afford a lawyer. We took up his matter, and after just 3 appearances in court, Eric regained his freedom. Like Eric once was, almost 70% of the people in Nigeria prisons have not been convicted. Many of them are only in prison because they are too poor to afford legal representation. And while some of these people are innocent, others will remain in prison for a period longer than the maximum sentence they will serve if found guilty. At the FEMA Project, we strongly believe that nobody should be in prison just for being poor. And it is for this reason that we help pretrial detainees, especially those charged with minor offenses, conclude their cases in court as quickly as possible. We do this by first identifying those in need of help. We do this through interviews conducted in prisons, as well as court case referrals from magistrates and members of the public. Then we assign their cases to our network of volunteer lawyers. Our target group of lawyers are young lawyers with no more than 5 years post-court experience. And then we ensure that the lawyers provide representation as efficiently and effectively as possible with the use of technology. The average length of pretrial detention in Nigeria is 3.5 years. On average, our cases are concluded from start to finish in just 5 months. The mobile app of the FLIMA project looks like this. This is what we use to ensure that our lawyers do what they are supposed to do, and they do it within time. We're different because we rely on a network of young lawyers. Many of them are seeking experience. And so we provide them with a platform that enables them to do so, and we provide them with an allowance for doing so. We cover the cost of transportation and documentation. And then we ensure that we monitor the progress of legal representation using technology, and so we avoid instances of case abandonment. In less than a year, we've represented over 100 pretrial detainees with just 7 volunteer lawyers. We've gotten over 49 pretrial detainees. We've enabled them regain their freedom through our efforts, and these are some of those people. We're funding what we do with our Waste for Justice campaign. We're partnering with companies to use recyclable waste donated to us as part of the CSR to fund what we do. And then we're working with a waste collection company, a social enterprise specifically, Chanjadati, to get 30,000 naira in exchange for each ton of waste. Our cases cost 30,000 naira to handle from start to finish. And if we're able to get 10,000 tons of waste, we're able to represent 10,000 legal pretrial detainees. Plastics alone constitute 2.5 million of waste generated in Nigeria annually. One lawyer can handle 20 cases. We've realized this during the course of our work. We work with young lawyers, as I've said, and the existing pool of young lawyers in Nigeria keeps growing every year by an average of 3,000, especially in the past 5 years. For next year, we're partnering with P1. P1 to represent over 1,000 pretrial detainees all over Nigeria. And we're open to work with 50 lawyers to do this. To reach our lawyers, we're working with the Legal Aid Council of the NYSC group, as well as the Young Lawyers Forum of the NBA. This is myself. I am the project lead of this project. I worked with the presidency for 2 years before I started this project. And so I've interacted with a lot of government agencies. And the relationships built then have enabled us to navigate through difficult circumstances with government officials. My co-founder, Ubok, has a sound understanding of court processes, especially at the magistrate court level, where most of our cases are. And she's an active member of the Young Lawyers Forum, and so she's been very instrumental in helping us get lawyers on board. Dami, the head of our tech team, is a talented software engineer. He has experience building apps for US-based startups that have been launched. We strongly believe that nobody should be in prison for being poor. Being poor is not a crime. Or we have a criminal justice system where it is better to be rich and guilty than it is to be innocent and poor. That is injustice. And let's not forget that injustice anywhere is a threat to justice everywhere. Thank you.
Okay, I look to our jury. Questions for Flamer Project? You'll need to press and hold the button for a minute.
Of course, excellent job. Aside linking up with waste management companies and exchanges, what other business models do you think that you can use to sustain this?
Okay, so during the course of our work, we also realized that there are levels to poverty. While some people are too poor to afford anything, some are actually able to afford something. So we've been able to provide legal representation for some of those people. Through that, we generated 840,000 naira, and we use that to provide representation for more people.
So you said 30,000 naira is to process the case.
Yes.
So how do you cater for the cost of the software, your living expenses, and all that?
Actually, 30,000 naira is an estimate. I said it takes about an average of 5 months. We've been paying our lawyers about 1,500 naira per representation. So if the matter takes a year, which is highly unlikely, it means we're paying a lawyer 24,000 naira. So 6,000 naira comes back to us.
My question is also about the business model. How open are you to also kind of try other ideas that could fund?
Very open. That the reason why we decided waste recycling is going to work for us is because we're desperate to find something that works. So anything that works for us, we adopt it.
Okay, thank you. One more round of applause. Okay, now what we've found over many years is at about 4, your brain starts melting because it's all new ideas, it's new stuff, recycling, airline compensation, approval for financial services and identity, peace in northern Nigeria. It's like, whoa. So we're going to take a little break from Justice Innovations. First, I wanted to recognize just arrived Mrs. Rauta Dakok, the Solicitor General and Permanent Secretary of the Ministry of Justice in Plateau State, who came all the way down from Plateau State to support the community peace initiatives. Rauta, hello, you're very welcome. Rauta also was able to attend one of our training days this week to see her team in action. So we very much appreciate your presence and your interest in this competition. It is my honor to introduce our keynote speech. Your Lordship, Justice Yatunde Adesanya, the Judge of the Lagos State High Court, and the Chairman of the Small Claims Court Committee. Will you join us on stage, please? You're very welcome.
Thank you for having me. Good evening, and permit me to stand on the already established protocol. The Small Claims Court in Lagos State. The Small Claims Court is a global concept which has been in existence in some form in almost all the developed countries as far back as the early 20th century. For example, the Small Claims Court in Washington, D.C. was established in the 1930s. And more recently, small claims courts have been established in a lot of developing African countries like South Africa, Kenya, and Rwanda. The need for the modern small claims court was recognized in 1913 by Dean Roscoe Pound in the Administration of Justice in Modern City when he said, and I quote, "For ordinary causes, our contentious system has great merits as a means of getting at the truth. But it is a denial of justice in small causes to drive litigants to employ lawyers. And it is a shame to drive them to legal aid societies to get as a charity what the state should give as a right." End of quote. According to Pound, when a claim cannot be enforced because the relative cost is prohibitive, there is a denial of justice. The administrative costs, complications, and other difficulties are no excuse for these denials of justice. As such, something must be done to enable these claims to be effectively enforced through a very cheap and effective, efficient adjudication process. The establishment of these courts can therefore historically stemmed from the recognition that enforcement of simple monetary disputes needs to be resolved differently and should not be subjected to the complexity of regular court processes, which can be prohibitive and discourage parties who would ordinarily come to court for the resolution of their disputes from doing so because they simply cannot afford the cost of legal representation and other incidental costs. There was therefore a need for an accessible, inexpensive, speedy forum for resolution of small monetary claims. Jurisdiction of the small claims court is limited to actions for the recovery of money, that is, simple debt recovery disputes, by which we mean a liquidated monetary demand as opposed to complicated commercial disputes. No action can therefore be brought in the small claims court for torts, recovery of premises, specific performance, declaratory reliefs, or any other non-monetary remedy. Generally, the monetary jurisdiction of the small claims court in the different countries of the world varies and are dependent on the threshold as determined by each country. In Lagos State, the monetary jurisdiction of the small claims court is 5 million naira and up to the limit of 10 million naira for a counterclaim. The success of the small claims court has been demonstrated across many countries, and it has been recently recognized as a good practice for courts worldwide and as part of the new methodology used by the World Bank Ease of Doing Business project for assessing contract enforcement indicator. In Nigeria, in almost all the states' judiciaries, enforcement of small claims hitherto has been within the regular magistrate court system, which in Lagos State presently has its monetary limit of jurisdiction set at not more than 10 million naira. Unfortunately, this process is complex, is long, is expensive, and not very efficient in enforcement of contracts, particularly for small claims, which ironically account for a good percentage of the cases filed at the magistrate courts in Lagos State. These are for reasons that are not attributable to the magistrates who sit in this court. So I beg to differ with the learned SCN, Mrs. Adekoya. I think she may have left. Well, some of the problems associated with that system include the following: no specialized divisions in the magistrate court, unlike in the High Court of Lagos State. In effect, magistrates are assigned all manner of cases: criminal, landlord and tenant, commercial, tort, etc., and they are required to give equal attention to all these cases before them. They therefore have no obligation to give priority to commercial matters or even small claims. The complexity of the processes to be filed for instituting an action itself in the magistrate court are also such that do not encourage self-representation because it is simply not simplified legal representation in almost all the matters. Although constitutionally a party to an action in court can choose to represent himself, however, in almost all the cases filed at the magistrate court, as in the High Court, parties are represented by counsel, which translates to greater expense and formality. There's also the formality of hearing and determining all interlocutory applications before proceeding with the substantive matters. All of the above stated challenges that plague the justice delivery system of the magistrate court in Lagos State made a strong case for the separation of small claims for fast-tracking and speedy resolution. This therefore informed the decision of the immediate past Chief Judge of Lagos State to establish the Small Claims Court on the assumption of office in October 2017. Coincidentally, the Small Claims Court was also part of the reforms advocated by the Enabling Business Environment Council, PEBEC, in the creation of an enabling environment for Nigerian businesses. Nigeria was ranked 146 out of 190 countries in the 2017-2018 World Bank Ease of Doing Business report, using data collated from Lagos and Kano, which are identified as key business hubs in Nigeria. One of the key indicators used in this ranking is enforcement of contract indicator. That is measuring the efficiency, time, and cost with which disputes involving small claims contracts are resolved, and the quality of the judicial processes that parties have access to. The timing of the establishment of the Small Claims Court in Lagos State in April 2018 was therefore greatly influenced by the timetable of PEBEC. In January 2018, the Chief Judge set up a 5-member committee of the Small Claims Court, comprising a judge of the High Court, my humble self as chairman, and 4 magistrates, 3 of whom were chief magistrates, one of whom is also seated here. The committee was required to draft a small claims court procedure and guidelines and make recommendations for all matters incidental to the operation of the small claims court within the magistrate court system. It was interesting to learn, in the course of working on the practice directions for the small claims court, the facts and figures about small and medium-sized enterprises, SMEs. That is, that they account for a greater percentage of businesses in Nigeria and are responsible for the majority of new jobs created in Nigeria. In other words, they contribute to wealth creation and generate tax revenues. SMEs are therefore crucial to Nigeria's success in the global economy. SMEs, as defined by the CBN, are economically independent companies with about 11 to 300 employees and an annual debit turnover of between 5 million to 500 million. So the main factors determining whether a company is an SME: 1, number of employees, and annual debit turnover. Since the limit of the jurisdiction of the newly established small claims court is 5 million naira, excluding interest and costs, and where a counterclaim is filed in the same action, it is allowed up to the limit of 10 million naira, it was envisaged that the small claims court will be constantly used by the SMEs along with private individuals. I'm glad to say that this has been the experience. It was therefore imperative that these SMEs were provided with easy access to quick and efficient resolution of contract-based disputes so that their much-needed capital was not tied down in prolonged litigation with crippling effect on their businesses and the economy of the country at large. The enabling provision of the Small Claims Court is the Magistrate Court's law practice directions on small claims. I have a copy here. This is what it looks like. It's a small book. By the practice directions, 15 magistrate courts across the 7 magisterial districts of the state were designated as small claims courts by the Honorable Chief Judge. Purpose, objective, and operation of the small claims court. The objective of the small claims court's procedure is to provide easy access to an informal, inexpensive, and speedy resolution of simple debt recovery disputes in the magistrate court of claims not exceeding 5 million naira. The primary purpose of the court is to provide a less formal, relatively inexpensive forum in which parties to a contract can resolve their disputes very quickly and possibly represent themselves at the hearing of the matters. As stated earlier, the monetary jurisdiction of the small claims court is set at 5 million naira. But by Article 7.2 of the practice directions, a counterclaim is allowed up to the limit of 10 million naira, which is the limit of the general jurisdiction of the magistrate court. The rationale for allowing a counterclaim up to this limit is to discourage a mischievous defendant counterclaimant from filing a counterclaim in excess of 5 million naira for the sole purpose of taking the claimant's action outside the limit of the small claims court and put it in the regular track of the court to delay the process. The small claims court is aimed at achieving simplicity in its practice and procedure. Every step in the procedure has been reduced into standard forms, which the claimant or defendant counterclaimant, as the case may be, simply fills and files, i.e. we have the letter of demand, we have the complaint form, we have the claims form, and so on and so forth, thus eliminating the complexity involved in the settlement of pleadings and filing of processes. For this purpose, we have forms SCA 1 to SCA 8, with clear instructions written on them, that is, when to be served and with what accompanying documents. The handling and hearing of the cases are also simplified. That is, the rules of evidence are relaxed. An example of that would be, rather than refusing and marking an exhibit which is not inherently inadmissible as tendered and rejected, the court would allow a party to bring in an admissible copy of the document at the next date of hearing. We do not and we cannot advocate non-compliance with the provision of the Evidence Act, which is a federal statute, and parties are still required to give their evidence on oath. The simplicity of the procedure is in turn aimed at encouraging self-representation, with emphasis. Article 10 of the Parties Direction provides that parties may represent themselves at the proceedings in the Small Claims Court. Partnerships and registered companies can be represented by either a partner, company secretary, or any other principal officer of the partnership or company. Self-representation, as you've heard the panel of speakers, presents a less acrimonious outlook of the proceedings as opposed to both parties having legal representation. Relationships between parties to an action where they have both represented themselves are more likely to be preserved. Let me be quick to add that parties are not precluded from being represented by counsel, as that would be unconstitutional. But we are, however, hoping that the simplicity of the process will encourage self-representation and thus reduce the expense of securing legal representation in these matters. The procedure is therefore inexpensive. To further encourage self-representation, there's a handbook of the Small Claims Court which explains every step of the process, guides through the filing of the forms, and provides answers to almost every conceivable question that a party who is desirous of using the process may have. In May 2019, that is a year after the establishment of the Small Claims Court in Lagos State, the Lagos State Judiciary launched the translations of the Practice Directions and Handbook into 5 local languages: Yoruba, Igbo, Hausa, Egu, and Pidgin English. This is to encourage inclusiveness and greater access to the court and further promote self-representation by litigants that are not literate in English. I do observe that the need for Nigeria to actively promote accessibility to justice institutions, especially among the least educated of its population, for the purpose of improving legal empowerment, is also advocated by Hill in his research on trust and legal empowerment in Nigeria. Alternative dispute resolution is also at the heart of the Small Claims Court, and it is deployed to decongest the dockets of the magistrates. Efficiency, which are some of the benefits. The procedure is fast and efficient. That is, every step is time-bound with sanctions for defaults. Timelines are to be strictly complied with. The entire hearing period from the first date of hearing, inclusive of the time allowed for exploring amicable settlement, must not exceed 30 days. The entire period of proceedings from filing till judgment is not to exceed 60 days. Adjournments are granted only in exceptional cases and may not be granted more than once to a party during the entire proceedings. In order to ensure that these timelines are strictly observed, determination on interlocutory application shall be reserved to form part of the judgment, and that's stated in Article 12.1. The use of performance assessment report on a case-by-case and monthly basis of all cases assigned to a magistrate of the Small Claims Court ensures that we can assess the efficiency of the individual magistrates of the Small Claims Court and the system as a whole. This is also to provide the judiciary with valuable data for improved justice delivery of the system. I have set out here a summary of data collated from the operation of the Small Claims Court in Lagos State from May 2018 to March 2019. In that time, a total of 850 cases were filed. The total number of judgments delivered out of that 80 cases was 530. 530 judgments out of 850 cases filed. The total number of judgments delivered within the 60-day timeline was 340 judgments. That is over 64% delivered within the timeline. Total number of judgments delivered outside 60 to 100 days was 147. Total number of judgments within 100 and 200 days was 42, and only one judgment was delivered outside 200 days. As part of the requirement of the World Bank assessment and for accountability and transparency of this judicial process, the above stated data from the Small Claims Court, that is the performance reports and copies of the judgments of the Small Claims Courts, are available on the Lagos State Judiciary website, which is provided at www.lagosstatejudiciary.gov.ng. Just click on it and you see all of this that we're talking about. In May this year, I was part of the Nigerian delegation of reform champions in the public sectors and PEBEC to the World Bank. We were there to present the reforms in the different sectors for the purpose of improving the country's ranking at the next annual World Bank ranking, which took place in October. I'm glad to say that the various presentations by the Nigerian delegation yielded the much desired result. On Thursday, 24 October 2019, the World Bank 2020 Doing Business Index, DBI, ranked Nigeria 131 out of 190 countries, up 15 places from 146 position last year. The report also named Nigeria one of the top most improved economies in the world for the second time in 3 years. I thought somebody would clap. Nigeria is one of only 2 African countries to make this highly prestigious list. With this year's leap, Nigeria has improved an aggregate of 39 places in the World Bank Doing Business Index since 2016. The Doing Business Index is an annual ranking that objectively assesses prevailing business climate conditions across 190 countries based on 10 ease of doing business indicators, one of which, as earlier stated in this address, is enforcing contracts. The index captures ease of doing business reforms that have been validated by the private sector. It's not just what we tell them. They actually do private sector validation and offers comparative insights based on private sector validation in the 2 largest commercial cities in countries with a population higher than 100 million. The report consequently features Lagos and Kano for Nigeria. The hard work that has gone into this new ranking should be greatly applauded, particularly when it is appreciated that all countries that are ranked by the World Bank are also assiduously working to improve on all the key indicators and thereby improve their business environments as we are. Conclusion. There are clear indications that the small claims court procedure in Lagos has been very much embraced and the courts are widely used. The procedure has clearly resolved some of the problems highlighted earlier in this address and has achieved most of the objectives for which it was created. The success of the small claims court has had a ripple effect, that is, decongesting the magistrate courts, fast and speedy disposition of small claims, improving the economy of the state and the country at large. It has also positively impacted on the global outlook of the nation and, of course, World Bank ranking on ease of doing business in Nigeria. We are presently collating data to validate the position that the operation of the small claims court is now helping to decongest the High Court in Lagos State in the enforcement of monetary claims within the jurisdiction of the small claims court, and that litigants are now more likely to reduce their monetary claims to bring it within the jurisdiction of the small claims court rather than go to the High Court. The case of a bird in hand is worth 2 in the bush. The Lagos State Judiciary is constantly reviewing the operation of the small claims court and addressing the challenges that crop up. It has, in the first quarter of this year, following a clamor by lawyers, expanded the scope of operation by allowing claims for arrears of rent, which at its inception was excluded under a general exclusion of landlord and tenant matters. The Lagos State Judiciary has also addressed and resolved a number of administrative issues, i.e. inadequacy of staff, by the employment of more magistrates and court sheriffs. We also ensure that we do not assign new small claims matters to magistrates in the last 2 months of commencement of the annual leave to avoid delay. We organize continuous training of magistrates and personnel of the court, the assistant chief registrars, the court registrars, and sheriffs of the small claims court. We are presently collaborating with the Lagos State Police Command to improve the execution process so that the judgments are not just Pyrrhic victories, particularly of judgments of the small claims court. We are also considering increasing the number of small claim courts from 15 to 20. We recognize the need for more publicity and sensitization of the existence and operation of the small claims court. We will continue to adopt the best global practices for improved justice delivery in this sector. On a final note, you could say that, like Hill, the Lagos State Small Claims Court is providing user-friendly justice that is affordable, accessible, and easy to understand. I thank you for your attention.
There's a lot in there that I hope that our innovators take, because one thing we worked on this week is key metrics that all of our justice innovators need to look for. So when we hear the key metrics of informal, inexpensive, speedy, simple, and then we hear that 64% are resolved within 60 days, we know that the metrics are being hit. So congratulations for the great work so far for the Lagos Small Claims Court. It's very impressive. One thing that we were happy about this last year is that we met a program that is along the subject lines of the Flamer project, actually, the Informal Justice Court project. That is, and there's a little section about this in your program. This is a multidisciplinary research project into the awaiting trial detention situation in Lagos since 2018. And this is, I think it's a really interesting research project. Our team has been really quite fascinated in this because the Hill data is broad and it's about people on the street, the everyday person. But when we find research projects that specifically delve into one particular population, especially those that are awaiting trial in prison, we really try to also incorporate that data in what we do and how we understand justice systems. So it's not only our data. So I believe they're not here at the moment, but they have set up some signage outside. It's in the program, and they've sent us a brief video. So could I ask our friends in the back to play the video from the Informal Justice Court project?
Hello, attendees at the regional final in Lagos of the Justice Challenge organized by Hill and the Dutch Consulate. My name is Joost van Onna. I'm greeting you from the Netherlands. Together with Melis Smets, we are part of an organization called Aardschap Foundation. And we are carrying out a research project in Lagos into the awaiting trial situation in Lagos prisons. This is a big justice challenge, not only in Lagos, but around the world. About 15 million people are locked up every year and have to await their trial behind bars, sometimes for months or even years. And together with a broad network of NGOs, universities and other organizations, we are studying this problem and we are trying to find innovative solutions. And for this, we work together with artists and academics and NGOs and to combine all efforts to make tangible this complex situation, but also tell the tale on a human level so other people can understand what is really going on. We've been doing this research for about 2 years, and what you're gonna see in a video presentation is some of our efforts that we have carried out in this time period, organizing expert meetings, doing interviews, organizing seminars, and organizing expositions in Lagos, where we brought together the important stakeholders. And next year we're gonna plan to do a next step and embark on a training program for awaiting trial inmates, where they are assisted by pro bono lawyers and are carrying out mock trials in which they perform the different tasks you find in a regular court, like a judge, like a jury, like a defender. And in this way we try to understand through action research what possible solutions are there to be implemented. This is a project that is supported by Hill, by the Dutch Consulate, the Embassy of the Netherlands in Lagos, and other organizations, among others, the Lagos Public Interest Law Partnership. It's very important to mention them and the important role in the Nigerian Prison Service. You're now going to see some footage of our project. We hope you like it. If you have questions or remarks, please reach out to us. On the website you will find in the presentation. Greetings from the Netherlands. Hope to see you soon. And good luck to the finalists. Goodbye. Hello.
So yeah, I suppose we're not seeing footage, but it's something. So it's listed in your program. So definitely something to check out. You can just simply Google the Informal Justice Court Project and find out. One of our principles as Hill is also trying to blend art with what we do. It seems very strange and weird, but what we find is that art is a good way of expressing for people a lot of the pain that they go through and a lot of the things that they experience. And so we always reach out to projects that are also blending things like data and art and different approaches to justice, because just one approach is not going to cut it. Okay, look, I don't know about you guys, but I'm ready to hear the last of the 3 justice innovations. What do you think? And can we get a big round of applause for the first 4 so far? Very good. Okay, then I think we're ready to continue. I look over at my friend with the slides. I want to mention one thing. You're hearing some music as they come up, and it's just because we've been hanging out all week, and we had a little session where we were just sharing some tracks that inspired us, some music that we like, and so they each chose a song that is sometimes successfully going on as they come up on stage. So that's the reason that there's music playing. They've each chosen a song that inspires them. So. As I mentioned, this competition is a very regional competition since we have Nigeria, Ghana, Benin, and Senegal represented. So our next 2 startups are both from outside of Nigeria. And this next one is from the country of Benin, representing Lilian app. Please welcome Alau Ajessa. Alau, you're very welcome. Second. It wouldn't be a finals competition if there wasn't at least one technical problem. It just follows in the long... And Lilian, whenever you're ready.
Good evening, everybody. So I'm going to introduce you, Lilian. Here is the fact. It takes hours of reading on search and researches to provide a single legal advices. That's what makes it expensive when it's provided by legal professionals. And that's why small companies like startups can't always afford it. Sadly, this also applies to less wealthy people that are often victims of their rights abuse. And that is the situation of 46% in my country. That is a big problem. While you especially know that in the growing up process, a startup encounters a compliance problem. And when you are in a system where ignorance is not an excuse, ignorance of law is not an excuse. So, to solve this problem, we used artificial intelligence to build a mobile application that we call Lilian, that we can speak or write with to get an affordable, useful legal advice. With only 3 buttons, like a microphone, a test zone, and a WhatsApp shortcut. Lilian is easy to download, is easy to use. She even speaks in Pidgin, and you can get it on Play Store. When you have a problem and you use Lilian, you are sure to get the minimum useful knowledge to direct, protect, or defend yourselves. And if Lilian is not getting you right, you can come in through the WhatsApp shortcut, and we came in to help you get better. So, let us see how Lilian works.
Dans 10 domaines de droit, c'est révolutionnaire. Écrivez votre réponse ou parlez-lui. Elle vous répondra. Elle est intelligente.
Sorry for the French, but as you can see, that's how Lilian works. And as you can see, inversely to any other existing solution, Lilian stands like a good mother that really cares. So, Lilian to date has been adopted by more than 1,000 persons, and she helps daily 10 to 20 users. Since our inception on our social media, Lilian has generated more than 700,000 commitments. And what you would like to know is how much it costs. Lilian is free, and it's going to remain free. But publishers are going to pay us for advertising through Lilian. Now, just let that one aside, and imagine how many entrepreneurs or how many savings Lilian is going to help entrepreneurs do per year. The fact is that in my country, there are 2,000 people that are creating a company, that are registering a company every month. And from day one to the end of the first year, they use an average of 600,000 CFA in legal needs. Our focus for 2020 is to reduce that for 200,000 CFA so that they can save 200,000 CFA per year. Now, let's just imagine if we can have Lilian speaking local languages. So in 5 years' time, we aim to have Lilian speaking Hausa, Yoruba, Fon, Mina, so that people that are not comfortable with imported language can be used to. Lilian is powered by a team of young jurists that are committed to justice, self-determination, and justice.
I've got to cut you off.
Thank you.
Okay, so you were... So I go to the jury to see if there are questions. Yes, Kanan.
Yes, I'd just like you to finish talking a little more about your team, please.
About
your team.
The team, yes. The team is made by young professionals.
Sorry, I think people that are speaking English as a second language should get a little bit more time. Yeah.
Thank you.
This is the more time to talk about the team, yes.
The team is about jurists. Can I have the please? So here is the team. The team is made of young jurists that are all committed to justice, freedom, and self-determination. We are also all ambassador of open data, and our developer is a member of Google Development Group. So our aim is to get Lilian be the search default for legal, and because we strongly believe that law should not be the preserve of legal profession, and that everyone should be self-reliant in the need of his justice. Thank you for having me, and that is it.
Another question from the jury? Yeah,
How many people actually use this to...
10 to 20 per day.
No, I mean, how do you determine if Lilian was useful? Not if they use the app. How do you determine if it solved their problem?
For now, we can't track that, but we are going to reach there. Because Lilian can be so useful that if it asks you to write a form and you don't know how